If you're recently divorced, here are 3 things you need to make sure you take care of concerning your estate planning. Hi, I'm attorney Chris Benson, and welcome to our YouTube channel, Listen to Your Lawyer. I've been in practice for over 30 years handling estate planning, probate, and bankruptcy cases. I'm going to tell you 3 things that you need to make sure you take care of if you're recently divorced. Number 1, if you're recently divorced, you need to make sure you change your life insurance policy. A lot of times people think that the divorce decree is some magical thing that takes care of everything in the world. And it's just not true. It does take care of a lot of stuff, but it doesn't take care of everything. There's some steps you need to take on your own directly with the insurance company. The biggest mistake we see people make when we're meeting with them concerning their estate planning is I'll ask them who are the beneficiaries of their life insurance policy. And a lot of times people just don't know. The reason this is a mistake is because when you originally get the life insurance policy, either through work or through a separate insurance company, the kids are young. You're newly married and you have young kids. Your only thought is, well, if I die, I need to make sure that my spouse has money to take care of the children. Life goes on. The kids get older. They are over the age of 18, or you get divorced, and you don't think about the life insurance policy again. So the number one mistake we see people make is that they'll fail to change the beneficiary of their life insurance policy if they're divorced. Here's the other part of that problem, is that if you're divorced and your children are over the age of 18, it's okay to go ahead and list them as primary or contingent beneficiaries. But if they're under the age of 18, it's super important that you have an estate plan in place, because they are legally incompetent to receive the money if you die. And what we do for our clients is we'll create a trust, and that trust will put real estate into the trust for the benefit of the minor children. You'll name a guardian on behalf of the minor children to watch out for them as people and also take care of their money. And then what we'll also have clients do is we'll have them change their life insurance beneficiary to the name of the trust. And so if something happens to you, then the cash comes into the trust, and the person that you pick then manages that money for the benefit of your minor children. Other attorneys might have a different approach, but that's the way we handle it, and it works out really well. The second thing that we see people make a mistake on is they fail to change the beneficiary for their retirement account. So 401k, SEPs, IRAs, things like that. Once again, in your particular situation, the divorce decree might put a lien on your retirement account for the benefit of your ex-spouse. And some places that's called a quadro order. But that's not really the issue. The lien's still there, or the entitlement to the retirement account or the percentage by the ex-spouse is one thing. But who gets the remainder of it? That's really the key. And once again, if your children are over the age of 18, well, then go ahead and name your minor children. But if your children are under the age of 18, then once again, it's really important that you name a trust as the beneficiary, because your children are legally incompetent to receive that not inheritance, but the benefit from the retirement account because they're under the age of 18. Now, our approach to that is to name the trust as the beneficiary or a contingent beneficiary of your retirement account. There is a downside to that. Now, in a retirement account, if you name a human as the beneficiary and you were to pass away, the human has the election to either roll it over into their own retirement account, or they can cash it out. If they cash it out, they pay income tax based on their individual tax rate. When you pick a non-human, you pick a charitable trust or a trust itself, or some third party that's not a human being, then there is no rollover option. There's only a cash out option. But it's not the worst thing in the world. So if you have minor children and you have a retirement account, the worst thing that happens is that the cash comes out of your retirement account. Income tax is paid on that money because the government's never been paid income tax on it. And then the remaining cash goes into a trust, and then the person that you pick becomes the manager of the money on behalf of your minor children, known as the successor trustee. And that way your kids get the benefit of the money. That's our firm's approach to handling those situations. And then the third thing that we see people goof up on is that they won't change their financial powers of attorney, their wills, their trust, because people once again think that the divorce decree magically changes everything that's going on in the world, and it's not true. What the law says is that if you have a will or a trust and then you get divorced, the decree actually gets entered, then we treat the named person as if they previously deceased the person who died. So it doesn't invalidate a will, or it doesn't invalidate a power of attorney, it doesn't invalidate a trust, the way we just read those documents as if that person predeceased you. The better way to go, obviously, is to do a new estate plan. Make sure that any real estate that you own is put into a trust so that it avoids probate for your children. It makes it easy for somebody to take care of you because now you're a single person. That's our firm's approach to it. So we do complete estate planning for people. But those are the top 3 mistakes we see people make. Consult with an experienced estate planning lawyer and find out what works best for you and your family. Thank you for watching this week's episode of Listen to Your Lawyer. I'm attorney Chris Benson. And remember, always listen to your lawyer.